one issue definitely comes into being as to what is the next procedure. Then one realizes and one examines and studies and he finds that. Is it not audible, Mr. Murthy?
It's audible.
No, somebody has written. Okay, thank you. So we all see into suspension of sentence, and suspension of sentence and stay of conviction are another facets which are normally discussed. And where does the suspension lie after the conviction? Whether it will be before the district judge or before the High Court or before the Supreme Court, what will be the journey, what we can say, under the criminal law after the conviction. These all other aspects we will be discussing in today's webinar of BeyondLawCLC. And we have amongst us Mr. Murthy Naik, Karnataka High Court. We thought, why not understand the nuances, because we have been seeing on the webinars a lot of sessions on appeal revision, but a very important topic, but as such, it's not being covered. Though as a young lawyer, I would say, when this particular part comes, he has to understand as to how the specific provisions are provided. You will not apply simplicity of 482, which normally says, like in Hindi, we say it's a Ramban, but it's not a Ramban for all. Once there is a codified law for a particular aspect, we have to go around with that. Before we ask Mr. Murthy, and what we normally keep on saying, go for the vaccination, that's safe. Always wear your mask, do social distancing, and don't go out in the market or meeting friends just for the sake of it. You should go minimal. That's the best way you can save yourself. And one of the way where we can think of drawing people towards their drawing room or their offices is through these virtual platforms. And all those who have been connected with us know that for more than 1 year, we have been taking the sessions forward. And those who have missed it can always like, share, subscribe the channel of BeyondLawCLC. They can also click the bell icon for the updates on the sessions of BeyondLawCLC. And without taking much time, I would request Mr. Murthy Naik to take things forward of suspension of sentence. Over to you.
Thank you, Vikas ji. Good evening, one and all. At the outset, I would like to thank the organizers of today's webinar for inviting me to speak on the topic suspension of sentence as provided in the Code of Criminal Procedure 1973. Before I deal with the subject, I would like to offer a small prayer for early resolution of the present pandemic. All of us are going through a difficult phase in our respective lives. Even in such a grim situation, technology has been of great help and it has enabled us to be in touch with each other, file matters in court, attend courts through video conference, participate in such webinars, debates, etc. I would congratulate Shri Vikas Chatrat and BeyondLawCLC for organizing series of webinars, and I'm told this is going on for the past 1 year. In fact, I have attended quite a few, and Trivikram told me this is going on since March last year. And such webinars have benefited all of us, and I hope that in future too such webinars would be conducted and we would keep learning. Now I would straight away touch upon today's topic, that is suspension of sentence. I have been told by the organizers that there are a couple of students who are watching this live. Hence, I would try to keep it as simple as I can without dwelling into unnecessary technicalities and intricacies, and would deal with the broad contours of the various provisions and the law that has developed over the period of time, so that it would be helpful to all of us in our professional life. Am I audible, friends? Thank you. Friends, today's topic being suspension of sentence in Code of Criminal Procedure. Hence, I would confine today's discussion to the Code of Criminal Procedure 1973 and the main features revolving around suspension of sentence. As Vikas ji rightly put it, suspension of sentence is the other side of the coin. Bail, pending trial, or during the pendency of the investigation or trial is mandated under section 437, 438, 439, etc. And in case of bailable offences, it is 436. Post-conviction, that is once the accused has been found guilty and he has been convicted and sentenced to undergo either rigorous imprisonment or simple imprisonment, he will have to seek suspension of sentence and get himself released on bail. So first and foremost, the provision that is available is 389 of Code of Criminal Procedure. And this deals with the suspension of sentence during pendency of an appeal before the appellate court and consequent release of the appellant on bail. This is the first part as contained in the CrPC 1973 as far as an appeal is concerned. Now, the second provision which deals with suspension of sentence is in exercise of revisional jurisdiction under section 397 of the Code of Criminal Procedure, which is exercised by the Sessions Court and the High Court. Thirdly, section 432 of CrPC speaks about power of an appropriate government to suspend or remit sentences. So these are the three main provisions which speak about suspension of sentence. The first two, that is section 389 and 397, are exercised by the law courts, whereas the third provision, that is 432, is exercised by the executive. So I would focus upon the first two provisions elaborately and would touch upon in the end section 432. Now coming back to 389 of CrPC, let me highlight the broad features of this provision. Friends, this can be exercised by a Sessions Court or a High Court. Now, before we go deep into the said provision, let me briefly touch upon the circumstances under which appeals are filed to the respective courts. Firstly, an appeal to the Sessions Court is filed from an judgment and order of conviction and sentence passed by a magistrate. There are many offences under the IPC and other statutory offences which are tried by the magistrates. In certain cases, there are special magistrates, such as Companies Act, etc., Negotiable Instruments Act, and so many other statutory offences where the trial takes place before the court of magistrate. After completion of trial, if the accused is found guilty and he is sentenced to undergo a fixed term of imprisonment, he can assail the said judgment of conviction and sentence before the appellate court. And the appellate court in such circumstances would be the sessions court. And the appeal would be filed before the sessions court, and along with the main appeal, an application under section 389(1) can be filed. The second set of facts or second circumstance where an appeal can be filed is to the sessions, is to the High Court, and that is from an order, from a judgment and order passed by the Sessions Court. That is normally when the Sessions Court tries a sessions case or a special court. For example, under the Prevention of Corruption Act, the special court is that of a sessions court. Hence, the appeal would lie to the High Court, and along with the main appeal, an application under section 389(1) can be filed. Having said so, I would go one step further and would try to emphasize that section 389(1) application can also be filed before the Supreme Court when you seek suspension of sentence. Friends, before the Supreme Court, there is no specific provision under either the Supreme Court rules or under the code to file an application for suspension of sentence. But an accused who is not in custody can file an application seeking exemption from surrender. That is before the Supreme Court. That we will touch upon a little later when we deal with section 389(3). So now in a given case where the accused is in custody and his appeal filed against conviction passed by the trial court has been upheld, or in an appeal against acquittal, if the High Court overturns the acquittal and convicts the accused, and if he is taken to custody, and then the accused will have to seek suspension of sentence by filing an application under 389(1) itself, even before the Supreme Court. And this can be found from a bare reading of section 389(1), which says that an appellate court, the word appellate court has been employed in section 389(1). Hence, this would convey that this power of suspension can be exercised either by the Sessions Court, High Court, or Supreme Court in an appeal filed against conviction and sentence. Friends, further, the use of the word may in said subsection would make it clear that suspension is not as of right but is discretionary. You could kindly look into section 389. The word may has been used and it is not the word shall. Friends, the power of suspension was found under the old code also. Presently, the 1973 code is in existence. Prior to that, it was the 1898 code, and the pari materia section was section 426 of the old code. I would refer to the 1898 code as the old code for the sake of clarity. Notable judgment on this point is that of the Privy Council. Not only notable, it is one of the earliest on this point, wherein the Privy Council was dealing with section 426 of the old code. And in the case of Lala Jairam Das versus King Emperor, which is reported as AIR 1945, Privy Council 94, it has been held that High Court does not have inherent power to suspend a sentence, but such a power can be exercised only under section 426 of the 1898 code. As in fact, during the introductory speech, Mr. Vikas referred to section 482, that is the inherent power of the High Court. Even under the 1973 code, a suspension of sentence can be sought only under the relevant provision if it is an appeal under section 389(1) or if it is a revision under section 397(1). A suspension of sentence cannot be sought by invoking the inherent powers of the High Court under section 482. That is the law, and which is similar or akin to what has been laid down by the Privy Council in the said judgment. Now, friends, 389(1) has two provisions. First proviso to section 389 mandates that if an appellant who is seeking suspension of execution of sentence has been convicted either for imprisonment for life, death, or for a term, imprisonment for a term of not less than 10 years, then opportunity to the public prosecutor to oppose such a suspension is a must. And opportunity is not mere oral hearing, but he should be given opportunity to file written objections. And the Honorable Supreme Court has dealt with the first proviso to section 389 in number of cases, and notable being, you may kindly make a note, is the case of Atul Tripathi versus State of Uttar Pradesh, which is reported as 2014 9 SEC 177. Here, the Honorable Supreme Court has held that first proviso to section 389 is mandatory in nature. Now, friends, the second proviso to 389(1) deals with the power of the public prosecutor to file an application for cancellation of the bail. That is, second proviso would come into play if the sentence has been suspended and the appellant has been released on bail. This is something akin to 437(5) or 439(2) of CrPC, which deals with cancellation of bail that has been granted to an accused during the pendency of investigation or trial. So the second proviso deals with the power of the public prosecutor to file an application for cancellation. So these are the two provisos to section 389(1). Now, as I dealt with the first proviso, the Honorable Supreme Court, in an earliest judgment and a very prominent judgment on this point of suspension under section 389(1), in the case of Kashmira Singh versus State of Punjab, which is reported as 1977 4 ACC 291, was dealing with a case where the accused was sentenced to imprisonment for life, and it has been held that the release of an appellant who has been sentenced to life imprisonment on bail pending disposal of his appeal would be justified when the court is not in a position to dispose of appeal expeditiously. In fact, the Supreme Court for the first time in this case held that the practice of not granting bail by the Supreme Court and High Court to persons who have been sentenced to life imprisonment was not correct. Friends, as you are aware, normally the high courts are slow in granting bail to appellants who have been convicted for imprisonment for life. Normally, imprisonment for life is awarded in heinous offenses such as murder, etc. Murder and kidnapping for ransom, 364A, etc., etc. So that being the case, the law courts are slow, and this includes the Supreme Court in granting bail to an accused, though an appeal would have been admitted. So in the case of Kashmira Singh, the Supreme Court for the first time examined and held that there is nothing wrong in suspending the sentence and granting bail to an accused who has been convicted for imprisonment for life. Then, friends, there was a lull for nearly 30 years. This was being followed by some courts, and some courts did not follow it. And after nearly 30 years, the Supreme Court, in the case of Siddharth Vashisht, that is the famous Jessica Lal case, the Supreme Court once again revisited this aspect of what is suspension of sentence and under what circumstances a sentence has to be suspended. In this case, the appellant, that is Siddharth Vashisht, who is also known as Manu Sharma, was convicted by the High Court in an appeal filed against acquittal passed by the Sessions Court. He was originally acquitted by the Sessions Court. Thereafter, the state went in appeal to the High Court of Delhi, and the Delhi High Court convicted him and found him guilty for the offense of murder. Hence, he was taken into custody immediately. And thereafter, when he approached the Supreme Court by filing a special leave petition, an application for suspension of sentence was filed. And while considering the said suspension of sentence, the Supreme Court once again revisited this aspect, and it held that the court it held that one of the main feature amongst others to be considered while dealing with an application under 389 is the time that would be consumed for disposal of the particular appeal. So the court applied the test of whether the appeal would be disposed of in a measurable distance of time. So this phrase, measurable distance of time, was coined and reiterated, and thereafter it was held that the accused was not entitled for the benefit of suspension of sentence merely because the appeal has been admitted. This Siddharth Vashish case is reported as 2008 5 SEC 230. Now, friends, coming further, this power of suspension of sentence can be exercised by the High Court when suspension has been refused by the Sessions Court in an appeal pending before it. This is as per section 389(2) of the CrPC. Now, friends, another important feature of this suspension of sentence is section 389(3). Here, the court which convicted the accused has the power to suspend the sentence and grant bail to the convicted accused for a limited period of time, so as to enable him to approach the higher court and seek bail. But under two circumstances. Firstly, a sentence can be suspended by the very same court if the accused is on bail during trial, and secondly, he has not been sentenced for a term not exceeding 3 years. So these are the twin requirements in the first scenario, where the Sessions Court or the court, be it the magistrate or the Sessions Court, which convicts a particular accused, can suspend the sentence for a limited duration. So the twin requirements are: one is the accused should have been on bail during trial, and second is the sentence awarded should not be more than 3 years. And the second scenario, the second situation in which a sentence can be suspended by the very same court is when the accused has been convicted for a bailable offense. For example, 304A. 304A is a bailable offense and is tried before the court of magistrate. So under such circumstances, if it is a bailable offense, the court which convicted the accused has power to suspend the sentence and grant bail. As I told you all earlier, this provision, keeping in mind the fact that the accused should be given a reasonable opportunity to approach the higher court. Hence, this has been considered and incorporated in section 389(3), but with a rider, as I narrated earlier. So those requirements have to be met. So in all cases, the court cannot suspend a sentence. For example, if an accused is tried for an offense under section 307 IPC by a sessions court, and the court finds him guilty for the offense under section 326 and convicts him and sentences him for a term of 5 years, then the sessions court cannot suspend the sentence. The accused will have to be taken into custody even if he was on bail during the pendency of trial. Hence, friends, not only the magistrate court or the Sessions Court can exercise this power in Section 389(3). In fact, the word employed there in 389(3) will have to be minutely examined, and it says 389(3) says the court which convicted the accused. So it can be the High Court also. For example, in an appeal against acquittal filed by the state challenging acquittal of an accused who was tried for offense under Section 307 has been convicted by the High Court and sentenced to undergo imprisonment for 3 years, then the High Court will be justified in suspending the sentence in exercise of its power and Section 389(3). But normally, these 389(3) applications are not filed before High Courts. And this has been dealt with by the Honorable Supreme Court, wherein it has been held that 389(3) is applicable where there is a right of appeal. In the case of Mayuram Subramaniam versus Srinivasan, reported as 2006, 5 SCC 752, the Supreme Court has held when there is a right of appeal, then 389(3) would be applicable. If you seek leave under Article 136 of the Constitution to file an appeal to the higher court, that is to the Supreme Court, then you cannot. So the rider is there has to be a right of appeal, then 389(3) is applicable. As I told you earlier, this is a very special and a unique provision. I would call it unique provision, this subsection 3 of Section 389. This is provided to the respective courts so that the benefit, the accused shall avail of the benefit, and sentence so suspended shall inure to him only for a limited duration so as to enable him to approach the higher court. Now, friends, these are the broad parameters revolving around suspension of sentence. Now, there was certain debate as to whether it is suspension of sentence or suspension of execution of sentence, and also the law courts went one step ahead and held that even suspension of conviction is permissible. Friends, if you all again examine, and I'm sure most of you all would be having CrPC along with you in your hand. If you examine 389(1), the word used is execution of the sentence or order appealed against be suspended. It is the execution of the order appealed or the sentence. But the law courts have given various interpretation to this section. A constitution bench of the Supreme Court, in the case of B.R. Kapoor, which is reported as 2001, 7 SCC 231, has held that it is not within the power of the appellate court to suspend the sentence. It can only suspend the execution of the sentence pending disposal of the appeal. Likewise, in another constitution bench judgment, that is in the case of K. Prabhakaran versus P. Jayarajam, reported as 2005, 1 SCC 754, it has been held by the Supreme Court that what is suspended is not the conviction or sentence. It is only the execution of the sentence or order which is suspended. Further, the Supreme Court has held that it is suspended and not obliterated. Friends, the first judgment, first Constitution Bench judgment which I referred to, that is the case of B.R. Kapoor. There was challenge to various provisions of the Representation of People's Act. There, the respondent number 2 was the then Chief Minister of Tamil Nadu, Srimati Jayalalitha, and her election as MLA and subsequent appointment as Chief Minister was challenged. And while dealing with the said petition, it was held that there can be only suspension of execution of the sentence and not suspension of sentence. However, friends, the Supreme Court in the case of Navjot Singh Sidhu versus State of Punjab, which is reported as 2007 2 SEC 574, and this is kindly note, this is a 2 judges bench judgment, has held that section 389(1) CrPC confers power not only to suspend the execution of the sentence and grant bail, but also to suspend the operation of the order appealed against, which means the order of conviction. And there, while dealing so with the said application for suspension of conviction, the Supreme Court relied on another judgment of the Supreme Court only, which is a 3 judges bench judgment in the case of Ravikant S. Patil, reported as 2007 1 SEC 673, and held that suspension of conviction is permissible. The reason for suspending the conviction was Navjot Singh Sidhu had encountered a disqualification by virtue of his conviction. He was tried and acquitted by the trial court, but subsequently he was convicted by the High Court in an appeal against acquittal. So in such a case, an application was filed for suspension of conviction before the Supreme Court, and the Supreme Court stayed his conviction. Similarly, in Ravikant S. Patil's case, the conviction was stayed on the ground that it was a case where Ravikant S. Patil was convicted for an offense of rape under section 376 IPC, and the conviction was stayed on the ground that there has been settlement between the prosecutrix and the accused. In fact, they had got married. So that weighed with the Supreme Court for staying the conviction. And in that case, the Supreme Court held that person seeking stay of conviction must draw attention to the appellate court to specific consequences that may arise if conviction is not stayed. Otherwise, stay cannot be granted. It also held that stay of conviction can be granted only in exceptional and rare circumstances where non-grant of stay would lead to injustice and irreversible consequences. Again, in the said case, that is Ravikant S. Patil's case, the Supreme Court stayed the conviction for the reason that he was an elected member of the Legislative Assembly and he had suffered disqualification by virtue of the conviction, judgment of conviction that was passed against him. Friends, these are all the judgments on suspension of conviction. But the earliest on this point is in the case of Ram Narang versus Ramesh Narang, reported as 1995, Volume 2 SCC 513. 1995, Volume 2 SCC 513. This was a case where the accused was convicted for offense under Section 120B and 420 of IPC, read with 114 of IPC, as he was encountering a disqualification under the Companies Act. A three-judges bench of the Supreme Court ruled that suspension of conviction was necessary and can be passed under the garb of suspension of order appealed against. So for the first time in Ramesh Narang, Ram Narang was Ramesh Narang's case, the Supreme Court has exhaustively dealt with the aspect of suspension of conviction. Thereafter, in the case of Sanjay Dutt versus State of Maharashtra, as all of you know, Sanjay Dutt was tried for an offense under the TADA Act in the Bombay 1993 Bombay bomb blast case, but he was convicted under the Arms Act. And there the appeal directly was to be filed to the Supreme Court as per the special statute. Hence, an appeal was filed to the Supreme Court, and there Sanjay Dutt not only sought for suspension of his sentence, but he also sought for suspension of his conviction on the ground that he wants to contest the parliamentary elections. But however, the Supreme Court, taking into consideration the seriousness of the allegations made and the evidence that was recorded by the special court, found it fit not to suspend the order of conviction, the judgment of conviction. Hence, it refused suspension of conviction to Sanjay Dutt. And that is reported as 2009 5 SEC 787. And this is a three-judges bench judgment. As far as special enactments such as Prevention of Corruption Act, the Honorable Supreme Court has held that though the power to suspend an order of conviction is available to the appellate court, it should be exercised in very exceptional cases. The exercise should be very limited and only when it is necessary, and it is found by the appellate court that the suspension, if the suspension of conviction is refused, grave hardship would be caused. Only in such cases, a conviction should be suspended. But in cases where the accused is convicted for offense under the Prevention of Corruption Act, the Supreme Court held that it should not be done. Notable case is that of KC Sareen versus CBI, reported as 2001 6 SEC 584. Friends, in a latest judgment, that is in the case of Preetpal Singh versus State of Uttar Pradesh, which is reported as 2028 SEC 645, the Supreme Court has distinguished sections 439 and 389 of Code of Criminal Procedure. It has copiously dealt with all the earlier judgments on the said point and has held that in a case of post conviction bail, that is, by suspension of operation of the sentence, there is a finding of guilt and the question of presumption of innocence does not arise. That is, when an accused is convicted after a full fledged trial, the question of presumption of innocence doesn't arise. Whereas in a case where the accused is facing trial or the investigation is under progress, then question of presumption of innocence is in favor of the accused. Hence, the Supreme Court held that question of presumption of innocence doesn't apply to an accused who has been convicted, nor is the principle of bail is the rule and jail is an exception attracted once there is conviction upon trial. It has been further held that in considering an application for suspension of sentence, the appellate court is only to examine if there is such patent infirmity in the order of conviction that renders the order of conviction prima facie erroneous. Where there is evidence that has been considered by the trial court, it is not open to a court considering application under section 389 to reassess and to reanalyze the same evidence and take a different view to suspend the execution of the sentence and release the convict on bail. Friends, I would once again repeat the citation and the name of the parties. It is reported as 2020 8 SEC 645 in the case of Preetpal Singh versus State of Uttar Pradesh. This is one of the latest judgment on the point of suspension of sentence under section 389(1) CrPC. Now, friends, the approach for suspension of sentence varies from case to case, depending on the seriousness and the nature of offense, nature of evidence led in by the prosecution, sentence imposed, etc., etc. There are variety of circumstances to be taken into consideration before suspending a sentence. Normally, friends, in cases where the accused has been convicted and sentenced to a term of less than 10 years, normally the sentence is suspended. But there are cases where the High Court or even the Supreme Court has refused suspension of sentence in cases where the accused has been sentenced to undergo imprisonment for less than 10 years. And the nature of evidence that has been led in by the prosecution. And another main feature, as I told you in the beginning, the main factor to be taken into account is the time that would be consumed for disposal of a particular case, that is a particular appeal. Because the whole purpose for suspending a sentence is that in the event the accused succeeds in the appeal and if he is kept in custody during the pendency of the appeal, then the entire exercise would be an exercise in futility. It would be just like a paper decree in civil suits. It would be just a paper acquittal, an acquittal on paper, whereas he would have undergone the sentence. And in Many number of cases in some high courts, such as UP and other high courts, which are overburdened, there are instances where the accused would have undergone the sentence for which he was convicted and sentenced to, and thereafter the appeals are heard and disposed of, and then the order of acquittal is pronounced. In such a case, it is nothing but an exercise in futility, and the accused will have to unnecessarily undergo the ordeal of sentence. Hence, this 389(1), or for that matter, the provision of suspension of sentence has been incorporated in the code and plays a very vital role. Friends, as I told you earlier, there are instances, especially in economic offenses, white-collar crimes, offenses of corruption. The High Court and Supreme Court has refused to grant bail. For example, in 2014, the then Chief Minister of Tamil Nadu was found guilty and was convicted for offense under the Prevention of Corruption Act and was sentenced by the special judge to undergo imprisonment for 5 years. Though she was on bail, because she was sentenced to undergo imprisonment for 5 years, she was taken into custody along with other accused, and they were also directed to pay a hefty fine. Hence, she approached the Karnataka High Court and filed an application for suspension of sentence. The Karnataka High Court refused to suspend the sentence and grant her bail on the ground that corruption has become a menace in the society. Hence, it was not a fit case for suspending the sentence. Another reason why the sentence was not suspended was that the accused had dragged the case indefinitely. The case was pending for nearly 20 years. It was originally pending before the court in Tamil Nadu, and thereafter it was transferred to Bangalore by order of the Supreme Court in a transfer petition. And thereafter a special court was constituted. And even thereafter, it took 10 years for the special court in Bangalore to decide the said case. Because for one reason or the other, the accused kept on dragging the case, kept on filing applications, filed various petitions before the High Court, challenging rejections of several applications, etc. Hence, the High Court held that the appellant was not entitled for suspension of her sentence. Ultimately, the Supreme Court granted her bail, and thereafter the appeal was decided. And of course, all of you know, ultimately the appeal against her, that is Jayalalitha, was abated, and as far as the other accused are concerned, they were found guilty, and the judgment of conviction passed by the special court was upheld. Now, friends, there are certain cases which are tried by the magistrates, certain statutory offences, such as under the Companies Act, Factories Act, Air Pollution Act, Water Act, there are so many acts and enactments under which the accused are tried. One enactment wherein number of cases are filed are the Negotiable Instruments Act. And in such cases, the approach is slightly different because this is a quasi-criminal offense. The approach is slightly different. When an accused who is convicted approaches the Sessions Court by filing an appeal, normally the accused is required to deposit certain portion of the check amount. Now, friends, this is as far as suspension of sentence as contained in section 389 of CrPC. Now, the second provision which deals with suspension is section 397. 397 is a concurrent provision of revision to be exercised by the Sessions Court or the High Court. Normally, suspension of sentence would arise before the High Court, according to me. That is because an order of conviction passed by the magistrate would be challenged in an appeal before the Sessions Court. And if the said appeal is dismissed, then the appellant accused will have to approach the High Court by filing a revision petition under section 397 read with 401 CrPC. Because friends, as all of you are aware, the Code of Criminal Procedure doesn't provide for a second appeal, unlike CPC. Hence, a revision will have to be filed. And this revision can also be filed when a Sessions Court overturns an order of acquittal passed by the trial court and convicts the accused. Hence, under these two circumstances, the revision can be filed to the High Court under section 397 read with 401. And again, the word employed there is suspension of execution of the sentence while calling for the record of the inferior court. So here too, the word suspension of execution of the sentence is employed. Friends, a revision, unlike an appeal against conviction, is not as of right. A revision petition is maintainable when the correctness, legality, or propriety of an order or finding of an inferior criminal court is in question. Hence, examination of factual aspects cannot be done by a revisional court. That being so, the person who has filed a criminal revision will have to make out a case and will have to impress upon the court that there is patent illegality or the order is palpably erroneous or suffers from serious infirmities which on the face of the record is visible. Hence, the High Court can call for record if such a case is made up. Hence, I would like to emphasize that there is vast difference between an appeal and a revision. An appeal against conviction is a statute right of every accused, whereas as of right, an accused cannot file a revision petition. Even under the 1898 code, there was provision for revision, and the pari materia section was 435. Section 397 of the present 1973 code is equivalent to 435 of the old code, and 401, that is power of revision of the High Court, is equivalent to section 439 of the old code. Now, lastly, friends, section 432 of CrPC deals with power of the concerned government to either suspend the execution of sentence or remit the whole or any part of the punishment to which he has been sentence. This power is exercised by the executive, and judicial courts have no such power under section 432 of CrPC, as has been held by the Supreme Court time and again. And the notable case being the case of Muhammad Al Hassan versus Union of India, reported as 2010 AIR SCW 6489. Friends, such power is given to the President as per Article 72 of the Constitution, and to Governor of a state as per Article 161 of the Constitution of India. Now, the Supreme Court, in the case of Epuru Sudhakar versus Government of Andhra Pradesh and others, has held that the judicial review by the High Court or Supreme Court of an order passed either under Article 72 or 161 of the Constitution of India is permissible. In the sense, this power is normally known as the power to grant pardon. And this order that is passed by the President or the Governor of a particular state can be challenged before the High Court in exercise of its jurisdiction under Article 226, or the Supreme Court in exercise of its power under Article 32. And this has been held in the case of Epuru Sudhakar and another versus Government of Andhra Pradesh, reported as 2006, reported in 2006 SEC. Hence, friends, these are the three broad provisions in the CrPC which deals with suspension of sentence. Hence, a brief sneak peek into the various provisions and the law that has traveled so far. Thank you.
This week, in fact, showed everything. It was not a bird eye view, but we got everything to know. And all the relevant judgments from Navjot Sidhu to Manu Sharma, then Jayalalitha, these are the judgments which the young students, as we are saying, have joined. But even while they are students or not even joined law, these were the judgments which we were often talked about. Yes, but the legal journey and what were the effects as such, or they would be, they have been given a, they say as their two-dimensional view, this is a third-dimensional view, which one could understand. Palak Gupta says difference between two sections was highlighted in Preet Pal Singh's. What is the difference between the two sections? What was that?
Sorry, can you be a little louder, Vikasji?
Difference between the two sections was highlighted in Preet Pal Singh's.
I can't hear you, Vikasji. You are not audible.
Yeah, now it's audible?
Yeah, better.
Yeah. It says you have referred to two sections that were highlighted in Preet Pal Singh's case. Could you just highlight it again?
Two sections in Preet Pal Singh.
Yeah.
Okay, that is the latest judgment of the Supreme Court. That is 2028 SEC 645. Yes, two sections are 439 and 389. As all of you know, 439 deals with power of the High Court and the Sessions Court to grant bail to an accused during investigation or during pendency of the trial. Whereas 389 is post-trial, that is post-conviction. The Supreme Court has very minutely distinguished. In fact, it has very copiously surveyed all the earlier judgments on the point and has held that the rule of innocence, presumption of innocence is not applicable to a convict, nor the principle of bail is the rule and jail is an exception attracted once there is conviction upon trial.
This is the, could you repeat the citation where second appeal is not maintainable, where conviction order is passed by the Sessions Court?
So it is not question of second appeal. I did not refer to any. It is, see, there is no provision of second appeal at all. Unlike CPC, there is no provision for filing a second appeal. It is revision, and revision under 397 only, wherein the legality, correctness, and propriety of an order or finding of an inferior criminal court can be essayed. So under the garb of this, an order of conviction passed by the appellate court can be assailed before the higher court, and normally it is the high court.
Gokul Das, accused is on bail during trial. On conviction by the Judicial Magistrate First Class, application has been filed for suspension of sentence. Whether the bail/surety needs to be furnished again?
Yes.
Okay, thank you. So we will unmute Trivikram. Trivikram.
I will add a bit. In fact, you before Trivikram takes over, as far as the last question is concerned, yes, one has to furnish surety. And even now, by virtue of amendment under 437A, surety will have to be furnished even if the accused is acquitted, till such time the appeal period is over. So the surety will have to be furnished, and this is only for a limited duration so as to enable the accused to approach the higher court. Thank you.
Yeah, Vikram.
Good evening, Mr. Vikas. Good evening, sir.
Yeah, good evening, Vikram.
Always a pleasure interacting with Murthy, sir, and it's a pleasure to participate in his webinar. He's like a walking library. I keep calling him because he has all the citation in his fingertips. And I think he has given us a holistic picture of this topic, suspension of sentence. And along with the citations, very useful citations. I think, sir, I would request you to kindly give us the soft copy so that Mr. Vikas Chatran can share it with the participants.
Yes, I will
make
do
use
that.
of this literature. It would be of great help.
Yeah, at least the citation, what is the broader aspects covered in that?
Yeah, I will email it to you, Vikas ji, as well as.
Yeah, or you can share it on the WhatsApp also.
Yes, I'll do that.
Yeah. So, friends, tomorrow do stay connected with us on partnership disputes and remedy. That is by Mr. S.S. Nagadant, a senior advocate from Karnataka High Court, tomorrow at 5 p.m. But before we part for the day, there's one question. It's by Murli Chaturnath. If an accused charged and tried under section 307 and found not guilty, can he be sentenced under section 326 even if he has not been charged under the same?
Yes, it can be.
Okay.
The Supreme Court has held it can be. A specific charge need not be framed when the court finds a particular accused guilty of a lesser offense.
Sir, I have a question. Sorry to interrupt.
Please.
You have earlier mentioned that it would be up to 3 years, but however, if a convict in a murder case, say he is convicted for
Kindly check your mic. Check your mic.
Am I not audible?
No, there's a lot of disturbances. Yeah, better.
If the accused is convicted under section 302 of IPC and he was not granted bail during the course of trial, so still does he have a right to move an application under for suspension of sentence?
To the same court?
No, before the appellate court. For example, Sessions Court has convicted him, and during the course of trial, he was not granted bail, and now he has preferred an appeal before the High Court. And can he move the suspension of sentence? And is there a chance? Can the court consider his suspension of sentence, considering the fact that he was not on bail during the course of trial?
Yes, of course, that would be a factor, but suspension of sentence is available to all the convicts, whether they were on bail or they were not on bail, irrespective of the offense, irrespective of the sentence. But only thing is, if a particular accused was not on bail during pendency of the trial, then that would be one of the factors that would be considered. And normally the appellate court takes that into consideration, whether the appellant was on bail during pendency of trial.
Are there any circumstances where the High Court or the Supreme Court has considered such an application where the convict was not granted bail during the trial? Have you encountered such a situation?
Yes, there are cases. In fact, there was, I think it is pending before the Supreme Court, which arose from our High Court. And it was the convict was not on bail, but the Supreme Court has granted bail. There are instances where both the courts have refused bail during pendency of trial and appeal, but the Supreme Court has granted bail. Likewise, even the High Court has suspended. See, if a particular accused is able to show to the court, either to the High Court or to the appellate court, that there is a palpable error committed by the trial court, then certainly the appellate court will take into consideration and would exercise the power of suspension. There is no bar as such.
Right, sir. Thank you so much. Thank you, Mr. Vikas.
Yeah. So thank you to Trikram, Murthy Naik, and to all those participants who have been watching us live on the YouTube and Facebook, coupled with those who have connected with us on the Zoom. Before we part, again, it is reiterated, kindly wear your mask, maintain social distancing, and contribute in whatever way you can contribute to the nation, because each one, as I say, earlier we used to say, each one can plant one, each one can teach one. But here I say that each one can contribute one in a social way, economically, physically, emotionally, in some manner or the other. Everybody is empowered to support that. So kindly do that. And as they say, this too shall pass. And those who have missed our previous sessions can like, share, subscribe, and click on our bell icon for the previous webinars. Do stay connected with us. And tomorrow at 5 p.m., we will connect on partnerships disputes with Mr. S.S. Naganand, the senior advocate, and Mr. Murthy Naik. We are enamored by the fact that you took us to the entire journey of suspension of sentence. And I'm quite sacrosanct that a lot of people would learn from it, and they will continue to learn once they watch the webinars which are on the YouTube. Thank you. Stay safe, stay blessed, devote as much time you can spend with your family and virtually with your friends on mobiles and the Zoom calls. Thank you.
Thank you. Thank you, Vikasji. Thank you, Vikram.